All right. Good morning, everybody. It's okay to say good morning back. My name is Richard Willis, and I'm a lawyer here in Columbia, and I have the honor of being the immediate past president of an organization called the South Carolina chapter of the American Board of Trial Advocates. And I can tell you there's nothing better than being the immediate past president, because it means that a lot of the responsibilities of the organization I get to pass on to my colleagues up here. I want to thank you guys for being here today. And I also want to thank all of the high school students and the teachers who are attending this by streaming. We're delighted to be back here live and in person in this amazing room, this auspicious place, to celebrate Constitution Day. And I'm going to talk to you just a little bit about Constitution Day and about what we're going to be doing this morning. We're here today to do something we call the James Otis Lecture. And you see some pictures around the room. You're going to learn a little bit about James Otis this morning. He was a remarkable person. This is the 13th year that the South Carolina chapter of ABOTA, that's what we call the American Board of Trial Advocates, has presented the James Otis Lecture in celebration and recognition of Constitution Day. So we're going to talk to you today about some pretty remarkable people, and we're also going to talk about the Constitution and what it means to us, what it means to you. We're going to hear from two judges today, Judge Leiden and Judge Hill. And then once they finish their remarks, we're going to open it up to questions. And as I said to you earlier, good questions, bad questions, it doesn't make any difference. We want to get some dialogue going about the Constitution. We're all lawyers, right? Everyone up here is a lawyer. Even Representative Smith's a lawyer, Judge Leiden is a lawyer, Judge Hill's a lawyer. And so we all deal with the Constitution in some way, shape, or form, probably every day. And so the Constitution is important to us, but it's not just important to lawyers. And that's, I think, what the point is of Constitution Day. It should be important to everyone and to you. And I want to take a couple of minutes to explain why. As we all know, unfortunately, we live in divisive time, and politicians in Washington seem to be at each other's throats. You turn on your television or you check your news feed on your cell phone, and you'll see all the reasons why we should mistrust and dislike the other side, whoever the other side might be. And we also know, unfortunately, that confidence in our public institutions, like our legislatures, our courts, seem to be at an all-time low. And discord, social discord, seems to be at an all-time high. But then we come across a day like Sunday, and that's Constitution Day, September the 17th, a little-known holiday. Constitution Day was established all the way back in 1940, right at the end of the Depression, right before World War II began. And it was founded by President Franklin Delano Roosevelt. And it celebrates, as you guys know, the September 17th, 1787 signing of the Constitution. And I'm sure, as you know, the Constitution is the document that defines the structure of our national government. And along with the Bill of Rights, the Constitution provides the means, the method by which we, the people, make sure that our government serves its important and legitimate purposes without violating our individual rights. And this may not mean much to the average person out on the street, and it's perfectly understandable to me for you to be thinking to yourself right now, hey, I'm just in high school. Why should I care about the Constitution? And so this morning we're going to try to help you answer that question. Now, a lot has changed in the United States and in the world since 1787. And as great as and important and innovative as that Constitution was in 1787, it wasn't perfect. And it's certainly fair to observe that as the Constitution was originally written in 1787, it left a lot of people out. And since then, amendments to the Constitution have improved on it. But the struggle for equality under the law, for women, for minorities, for the disenfranchised and the powerless in our country, that struggle continues to this day. It continues in our political arenas, it continues in our streets, and it continues in our courtrooms, and it involves the Constitution. But there's one thing that hasn't changed at all since 1787, and that is the need that we all have for a government that will protect our individual rights without abusing its power. And the Constitution is a big part of that. I was looking for something to say to you guys today, and I ran across an article by a newspaper writer named Timothy Snowball, kind of an easy name to remember. And I'm paraphrasing some of his article today, and one of the things he said that really rang with me was, the struggle for individual rights is the story of America. And so I'd like to tell you about one chapter in that story, in that ongoing story, really, about someone like you, a high school student who stepped up to become part of that struggle for individual rights. This wasn't very long ago. This happened in 2017. A young lady named Brandy Levy. She was from Pennsylvania. She was in the 9th grade, and she tried out for the varsity cheerleading squad at her high school, and she didn't make the team. And instead, she was assigned to the JV team, and she was disappointed about that. And so after a particularly bad day in school, I'm sure none of you guys have ever had a bad day in school. I see some smiles maybe. Well, after Brandy had a particularly bad day, she went home and she posted an angry message on Snapchat with her friend that was very critical of the school. And they used some words that when I was a child would have gotten my mouth washed out with soap. It'll probably, if you used them, it would probably get you put on restrictions for a couple of months. But in Brandy's case, the words she used in her Snapchat post, and I'm not going to say them here on the floor of the State House, but you can certainly Google it and look it up. Those words got her suspended from the JV cheerleading squad for a year. That's all. And she was punished by her parents, and she accepted that punishment. But the more she thought about the suspension, the more it occurred to her that that wasn't fair, that she shouldn't be punished at school for something that she said off campus. And so she did her research, and she talked to her parents, and they hired a lawyer, and they brought a lawsuit against the school district for violation of Brandy Levy's constitutional rights, her right to freedom of speech. And they tried that case in the district court, where Judge Leiden is a judge. That's the trial court, and they won. Imagine that. Little high school student beats the school district. And the school district wasn't happy about that, and so they appealed it to the Third Circuit Court of Appeals in Philadelphia, and they won there. And the school district was even more unhappy. And so the school district asked the United States Supreme Court to do what's called grant certiorari, which means accept the appeal. And believe it or not, the United States Supreme Court thought that Brandy Levy's case was important enough for their attention. And so they took the case. And in 2021, the United States Supreme Court decided 8-1, not 5-4, a clear majority, that Brandy Levy was right and that the school district had violated her First Amendment right to freedom of speech because they punished her for off-campus speech. This wasn't something she said at school. If you use offensive, vulgar language at school, you're going to get in trouble. Don't go back to school and say, well, the Supreme Court says I can do that, because that's not what they said. What they said is you can't be punished in school for off-campus speech. Now, the reason I mention this case to you on this important day in this impressive setting is to illustrate the point that the Constitution is not for the powerful. It's not for corporate interests. It's not for important people. It's for everyone. And it's particularly for the powerless. It was enacted for the benefit of all of us, and it's up to all of us, including you guys and the people who are watching on television, to preserve and protect and defend it. And to do that effectively, it helps if you understand what the Constitution says, what it means, and how it's been applied. And so that's what we're here to talk about this morning, and that's why we celebrate Constitution Day. All right? So we're clear what we're going to do. All right, my next job, then I get to sit down, is to introduce Representative Merle Smith. And he's going to welcome you to the State House. And I want you to look around. I know you already have. I jokingly say this is his office. It's really not his office, but he spends an awful lot of time in here. And this is a pretty sweet place. Merle is a lawyer. He's the 61st Speaker of the House, South Carolina House of Representatives, and this means that he's the presiding officer over everything that goes on in this room, and he has lots of duties, including preserving order and decorum in this chamber, so behave yourself, right? Representative Smith lives in Sumter. Sumter is where Nancy O'Dell of Entertainment Tonight is from. United States Representative, Minority Whip James Clyburn was born in Sumter. Country music singer Lee Brice is from Sumter. The late Chief Justice Ernest Finney, there's a statue of, he's in a statue right outside this building. It'd be worth going and looking at. He's from Sumter. Lots of famous people from Sumter. Merle graduated from Wofford College, as did Judge Hill, and the University of South Carolina School of Law, and he practices law in Sumter. Because believe it or not, being the Speaker of the House of Representatives in South Carolina is not a full-time job. Next to being the husband of Macaulay Smith and the dad of Mary Brown B. Smith and George Merle Smith III, I think maybe Merle's proudest distinction is probably that he's a member of the South Carolina chapter of the American Board of Trial Advocates. Let's hope so. Merle, thank you for hosting us here for this great day, and I'm now going to turn the proceedings over to you.
Thank you. Thank you for that wonderful introduction, and I want to welcome everyone here this morning. I'm pleased that at least some of us are here in person today, and so for those of you who are not, you're missing a spectacular time of being in the State House, and I want to welcome you. This is your South Carolina House of Representatives. This is what we call the People's House, and it's my pleasure to be here with you today. Constitution Day is a day to stop and honor our history and formation as a nation and the ways in which we have grown into the United States that we are today. I cannot think of a more fitting place to be celebrating it than this State House right here. I'd like to take a moment to talk a little bit about what I think this building symbolizes, as well as what it means to me to be a lawyer and also a legislator. I also like to tell you a little bit about the South Carolina Constitution and leave you with a few thoughts on the rule of law in today's world. In this year's lecture, theme is the rule of law, and this is going to be the theme that you hear us all talk about through the process, and rule of law is a very important concept to a functioning democracy. I know it's early, and y'all are hearing about this building and civil discourse, and it may not sound like the most interesting thing. I can see some of you over here, but if y'all who are attending virtually say your neighbor nod off, please nudge him and make sure he's paying attention for me. I want to tell you about the State House, and it's a perfect symbol of commitment to our history as well as to the growth and to progress. This building that we stand in today is not the original State House. You may be interested to know that the original building was not even in Columbia. The first State House was in Charleston until 1786 when the decision was made to move to a more central location. One of those locations was Statesburg in South Carolina, and I mean South Carolina in Sumter County, but unfortunately it moved over here to Columbia. The construction began on this building that we stand in 1851, but progress was halted multiple times and through fires and attacks during the Civil War. Nevertheless, this building was finally completed in 1803 and stands here today as a symbol of our unwavering commitment to the democratic form of government created by our Constitution. Like our State House, it took a couple of tries to get our governing documents exactly right. Also, like our State House and its builders, the builders of our nation were not deterred by setbacks and continued to work until this country and this system of government was constructed in the mid-1990s, meaning until this country and system of government was constructed. In the mid-1990s, this building underwent major renovations in order to preserve the integrity of the structure and to make sure it is accessible to all. The dedication to preservation is mirrored in our country's commitment to the preservation of our Constitution and to the idea that it protects all those who are born here or may become citizens. The State House is a house for all South Carolinians, and the United States Constitution is a document that shelters and protects all of the United States citizens. As a lawyer and a legislator, it is my solemn duty to uphold the Constitution of this state and of the United States. The creation of laws and the court system are tools by which we ensure that all Americans are protected by those documents. It is a true honor to serve in both of these roles as a lawyer and a legislator. As a lawyer, I work each day on behalf of my clients to protect their rights under the law, and both the state and federal constitutions create the judiciary, which is our legal system under which we all operate. As a legislator, I have a responsibility of helping to create new laws, but also to ensure that we don't create unnecessary or unconstitutional laws. And now, as Speaker of the House, I treasure and respect this balance more than ever. It is so very important as a member of the General Assembly to remember that balance. We only create laws that are needed to protect our citizens while we avoid infringement of the constitutional rights with government overreach. Lawyer legislators have been instrumental in shaping our state and our country's history since its inception. In fact, of the 55 framers of the United States Constitution, 32 of them were lawyers. One of the 4 South Carolinians who signed the Constitution, named John Rutledge, went on to become the original Associate Justice of the United States Supreme Court and the second Chief Justice of the United States Supreme Court. Throughout history, lawyers have continued to shape our laws and policies and are responsible for much of the progress we've made. Today, there are 54 members of this General Assembly that are lawyer legislators. And if you go across the hall over there in the Senate, you will see a portrait of James F. Burns, a notable 20th century figure in this country. He was a South Carolina lawyer who served as a congressman, then served as a United States Supreme Court Associate Justice, then Secretary of State, and eventually the governor of the state of South Carolina, making him one of the few politicians to serve at the highest level of all 3 branches of the federal government. One might wonder why so many politicians are lawyers, but I think the answer is relatively clear. When we join the bar, we take an oath to preserve, protect, and defend the Constitution of this state and of the United States. Protecting the Constitution is at the core of what we promise to do as lawyers to begin our career, so it's only natural many of us would feel a calling to work and help create laws that do just that. In fact, we make the very same promise when we're sworn in over here in the House of Representatives after every election, that we promise to preserve, protect, and defend the Constitution of this state as well as the United States. Both jobs require that at the end of the day, we're working to protect your constitutional rights. It is an honor to be able to make my living as a lawyer and to be elected to represent the interests of constituents as a legislator. In both roles, I get to work each day to preserve, protect, and defend the Constitution. You heard me mention a few times now only the United States Constitution, but our state also has a Constitution. Those oaths of office I just mentioned, the Constitution of the state and the United States, that's because we live in a federalist system in which the federal government shares power with the state governments. Therefore, all 50 states have adopted their own constitutions. While some of the content varies from state to state, they all share the basic tenets in common with the United States Constitution. For example, you'll find in Article 1 of the South Carolina Constitution language which mirrors the Bill of Rights of the United States Constitution and guarantees such things as freedom of speech, freedom of religion, and protection against unlawful searches and seizures. Just like our United States Constitution, our South Carolina Constitution begins with the premise that we all have a basic right to liberty. Our state preamble reads, "We, the people of the state of South Carolina, in convention assembled, grateful to God for our liberties, do ordain and establish this Constitution for the preservation or perpetuation of the same." And ultimately, that is the goal of democracy and the upholding of these constitutions, to preserve our liberty. The framers of this country and this state considered the right to liberty to be so important that protected at both levels of government, and that the protection is provided by the ironclad documents of the state and federal constitutions. Liberty is a word I'm sure you hear a lot when people are arguing about politics. One side is always trying to infringe upon the other side of liberty. The fiery rhetoric has become all too common in our everyday lives, and I'm here to tell you it should not be that way. I'm standing in a building today in which I serve with lawmakers from all across the state with vastly different backgrounds and beliefs than my own. We stand at the well below me right there, and we argue bills and have impassioned speeches and disagree with one another wholeheartedly. But after we adjourn, I walk down the steps of this state house back to my office with the same members whom I have disagreed with vehemently and chatting about our families and our lives. We often have lunch together and we truly enjoy each other's companies. I'm going to mention one of my friends, Todd Rutherford. He's the minority leader of the South Carolina House of Representatives, which I'm a Republican, and obviously we're on the different side of the political spectrum from one another. He's also an African-American Democrat from downtown Columbia. I am a white Republican from rural Sumter County. We disagree on many significant issues, but I can count Todd as one of my best friends in this body. He knows my family, and I know his family. We realize that we travel together and we socialize together, and he is a good man, a good friend, and someone whom I trust wholeheartedly. We have learned the important art of disagreeing without being disagreeable. Todd is a fellow lawyer, a legislator, and I know he serves both of those roles each day as committed as I am to the upholding of the ideals of the state and federal constitution, and is dedicated, as well as myself, to that ultimate belief that every person's inalienable and God-given rights. We may believe in different ways in which those rights should be protected, but I never question his commitment to the basic tenet of the preservation of liberty. We both know that the importance of the rule of law and respect it more than we could ever disagree about any issue. We do not allow issues to divide us in this body. It is this level of respect that I sometimes feel we are starting to lack as a society. As Americans and South Carolinians, we are all bound by the common goal that the preservation and protection of this document which we are here to celebrate today. Let us all remember the next time we find ourselves disagreeing with our friends, our family members, even your classmates, or whomever it may be, no matter our differences, we always begin with the common ground of the Constitution. Standing in this State House should be a reminder to all of us of the great responsibility we have as Americans to uphold the ideals of this Constitution. This building serves as a shelter for those men and women who gather each day to protect and improve the lives of South Carolinians. The Constitution is our great touchstone by which we are all able to do just that. I'm lucky to serve in this building along with fellow South Carolinians, each of us bound by the ultimate promise of the preservation and perpetuation of our liberty. And I'm honored to be here today to celebrate such an important document with you. And it's also my honor to welcome you again to your State House. So I appreciate y'all being here. And the next order of the agenda, we're going to stand and face the flag and say the Pledge of Allegiance. So if you'll please rise. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And next on the agenda is I get to welcome my good friend Anthony Lavoti, who is a practicing lawyer at Murphy and Grantland here in Columbia. So Anthony.
Thank you, Mr. Speaker. Well, I want to welcome you all as well here to the James Otis Lecture. As Merle said, I'm Anthony Lavoti, and I practice law here in Columbia, and I am the president-elect of the South Carolina chapter of the American Board of Trial Advocates. And I'm here to tell you a little bit about who James Otis was. Some of you may be wondering that, who is James Otis? Who was James Otis? I certainly wondered that when I began to learn more about this program. James Otis is often called the forgotten founder of our country. He was a Harvard-educated lawyer who practiced law in Boston, Massachusetts in the 1700s. At that time, obviously, Boston, Massachusetts was part of the colonies that were controlled by the British. And at this time, the British used something called writs of assistance. These were general warrants that members of the government, British soldiers, and even other citizens could apply to government to execute searches of people's homes. These allowed British soldiers and other officials to enter a person's home or business anytime they wanted to look for alleged contraband, and it gave the British free rein to enter at their discretion. And sometimes these writs of assistance were unlimited in their scope and unlimited in the time that they were able to be used. James Otis challenged these writs in a lawsuit that was filed in 1761. And this is considered to be one of the pivotal points and moments of the American Revolution. During the arguments in the case against the writs of assistance, James Otis said these words: "One of the most essential branches of English liberty is the freedom of one's house. A man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle. This writ, if it should be declared legal, would totally annihilate this privilege. Custom house officers may enter our houses when they please. We are commanded to permit their entry. Their menial servants may enter, may break locks, bars, and everything in their way. And whether they break through malice or revenge, no man, no court may inquire. Every man prompted by revenge, ill humor, or wantonness to inspect the inside of his neighbor's house may get a writ of assistance. Others will ask it from self-defense. One arbitrary exertion will provoke another until society be involved in tumult and in blood." John Adams, not a forgotten founding father, but yet the second president of the United States, listened to that argument when it was being made, and he gave credit to James Otis and those arguments that he made for sparking the American Revolution. The arguments that James Otis made formed the basis of the principles underlying the Fourth Amendment to the United States Constitution. And in 1791, 30 years after he first argued his case, the Fourth Amendment to the Constitution was ratified. The Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So we are protected from unreasonable searches and seizures by the government. It requires probable cause on oath or affirmation before an independent judge. And we have James Otis and his arguments to thank for that protection. So that's a little bit about who James Otis is and who he was and why he's so important to our celebration of Constitution Day. And at this time, I'd like to introduce Luther Batiste. Luther, another practicing lawyer here in Columbia, South Carolina, and Luther is a past national president of the American Board of Trial Advocates. Luther.
Good morning. Who is Matthew J. Perry, Jr.? Judge Joe Anderson, a federal district court judge in South Carolina, wrote the foreword for the book, Matthew J. Perry, The Man, His Times, and His Legacy. And he described Judge Perry in this way. To say that Matthew Perry was good in the courtroom is like saying Mickey Mantle knew how to swing a bat. Now, for those of you out there, you have no idea who Mickey Mantle is. Let me say it a different way. To say Matthew Perry was good in the courtroom is like saying Steph Curry or Kevin Durant know how to shoot a basketball. It's like saying J. Cole, Big Sean, or Nipsey Hussle know how to rap. His skill as an orator, his quick legal mind, and above all, his gentle nature still serve him as a member of our court, whose counsel is sought by other judges, Judge Anderson wrote at the time. He said that Aristotle taught that lawyers and judges should be the personification of justice. Matthew J. Perry comes as close as any person I've known in mastering Aristotle's ideal. Judge Perry's path to becoming one of the nation's top lawyers and judges was in a South and country very different than what we know today. The schools in South Carolina were separated by race and quality. Public accommodations were identified for whites only and for colored only. African American students like Matthew J. Perry were not allowed the opportunity to attend in-state colleges of their choice, like Clemson University or the University of South Carolina. Judge Perry grew up in an environment that was very unfair and very unjust. After enrolling at South Carolina State College, Judge Perry served his country in World War II as a member of the Army Quartermaster's Corps. He traveled throughout Europe serving his country. Prior to his service in Europe, he experienced an incident which would help cement his desire to become an agent for change in the social and legal structure of the South. Judge Perry and other members of his company, while in uniform, were not allowed to sit down and eat at a restaurant. He and his colleagues of color had to get food from an outside window and eat outside. As he looked into the window of the restaurant, he saw Italian prisoners of war seated and eating inside. Judge Perry in uniform outside, German prisoners of war inside. This experience had a life-changing effect on him. Judge Perry decided to challenge the institutional discrimination that was the norm in the United States at that time by becoming a lawyer. Judge Perry was not allowed to attend the University of South Carolina Law School because of his race. Instead, the state of South Carolina established an all-black law school at his college, alma mater, South Carolina State College. Judge Perry graduated second in his class. He graduated in his second class. At the time, it was customary that students who graduated from the state's public law school were granted automatic admission to the state bar. After the South Carolina State Law School opened and Judge Perry graduated, the rules suddenly changed. the South Carolina Bar instituted for the first time a bar exam as a prerequisite for admission to the bar. Needless to say, lawyers had their first experience with Judge Perry's ability to change the legal system in South Carolina. He was also the first person of color who graduated from a state public law school to pass the bar exam. Judge Perry started practicing law at a time when there were only 15 black lawyers in South Carolina, and the job opportunities for recent African American graduates of law school were non-existent. Judge Perry started a solo practice and established himself as a consummate trial lawyer, handling a variety of civil and criminal cases. He became one of the premier criminal defense lawyers in the state, and he was appointed by the Supreme Court to handle most capital cases where race was a factor. It is in the civil rights arena where Judge Perry really left his mark. He became general counsel of the South Carolina NAACP at the beginning of the civil rights movement in the South. He represented thousands of individuals arrested as a result of sit-ins, marches, and peaceful protests. Judge Perry had to endure scorn and mistreatment from judges and legal officials. He indicated that he and his co-counsel were often treated like garbage by judges. His words. Judge Perry knew that for many of the cases, a fair verdict was not possible at the trial level. He knew that he had to win on appeal, and on appeal he did win. Judge Perry has 96 published cases handled on appeal, 3 of which were argued before the United States Supreme Court. The legal legacy of Matthew J. Perry Jr. as a trial lawyer and appellate advocate is truly remarkable. Few lawyers today will have the opportunity to make the impact he did. His influence reaches far beyond the civil rights victories of the 1960s and 70s. In areas fundamental to the liberty of all Americans, free speech, freedom of assembly, equal protection, and due process, Judge Perry played an important and at times central role in the development of modern constitutional jurisprudence. His case of Edwards v. South Carolina laid the groundwork for the First Amendment jurisprudence for the next 50 years. The Supreme Court of the United States has cited this case more than 70 times in later decisions. His work in 4 sit-in cases was extremely important in defining the rights of demonstrators. His work in Newman versus Piggy Park Enterprises helps to strengthen the reach and force of the attorney's fee provision of the Civil Rights Act of 1964. Judge Perry brought the lawsuit that resulted in Harvey Gantt's integration of Clemson University in 1963. Mr. Gantt later became mayor of the city of Charlotte. His lawsuits resulted in the integrations of schools, hotels, restaurants, and hospitals in South Carolina. In December of 2002, Clemson University awarded Judge Matthew J. Perry an honorary doctorate degree and later hired him to be a lawyer for the university. As you would imagine, Judge Perry's actions were not well received during that time. A cross was burned on the lawn of his home. He, his wife, Hallie, and son, Michael, all received death threats. Law enforcement officials were assigned to guard his home on many occasions. One would think that anyone who had experienced such indignation, maltreatment, and hatred would be a very bitter and angry person. But it is a credit to Judge Perry's character that today he remains a revered person. He has garnered the respect of the legal community, the power structure, and South Carolinians in general. He gained this respect not only because of his exceptional accomplishments as a lawyer and judge, but because of his sense of fairness, civility, and never failing goodwill to all human beings. Imagine this in 1976, at a time when race relations were in transition. Senator Strom Thurmond, a former avowed segregationist, nominated Judge Perry to serve on the United States Military Court of Appeals. He became the first African-American lawyer from the Deep South to be appointed to the federal bench. In 1979, President Jimmy Carter appointed Judge Perry to the United States District Court of South Carolina. Judge Perry stated, "I never thought I would live to see a black man as a United States District Court judge, certainly not myself, because the cases I handle were not designed to win friends and influence people." Judge Perry had the rare ability to win the respect of his opponents while beating them in the courtroom in unpopular cases. Only a special person can accomplish that feat. Former Chief Justice of the South Carolina Supreme Court, Gene Toll, commented, "Perhaps only one with Judge Perry's deep reservoir of quiet confidence and civility of spirit could have inspired the admiration and respect of so many South Carolinians, including those deeply opposed to the cause of equality, for which he so ardently and effectively advocated all his life." Judge Perry is the recipient of many, many awards, but probably the most symbolic acknowledgement of his extraordinary life and work was the dedication of the 208,000 square foot courthouse dedicated in his honor on April 23rd, 2004 in Columbia. South Carolina Congressman Jim Clyburn was the moving force in getting the courthouse built and named for Judge Perry. Congressman Clyburn stated at the time, "Matthew Perry is a humble man who would never seek recognition for his extraordinary contributions to civil rights, the legal profession, South Carolina, and our nation. But I knew that given this opportunity, I would ensure that his legacy would be preserved in an enduring way so future generations could learn from this great man as I have." Judge Perry was an imposing figure, tall, handsome, eloquent, and articulate with a deep, melodious voice. He was an orator with a quick legal mind. His command of the language, a thing of beauty, and his command of the law was complete and powerful. His civility, dignity, wisdom, and tenacity have inspired a generation of youth to become lawyers. I was one of those young people who dared to dream to be like Matthew J. Perry. Heredity did not bless me with the tall, handsome stature or deep, melodious voice, but I did become a lawyer, and I came back to South Carolina to make a difference. My first law office in 1974 was the office of Judge Matthew Perry when he was a lawyer with Jenkins, Perry, and Pride. Imagine that, 24 years old, your first law office is your hero's law office. One of my greatest accomplishments was to win a case in Judge Perry's court. It is much more than an honor and privilege for me to tell you about my hero, my mentor, my role model, an extraordinary barrister and jurist, a prince of a man, a treasure to the state of South Carolina, who dedicated his extraordinary career to make the law a better tool of justice. Judge Perry was selected by the American Board of Trial Advocates, the organization that's presenting this program today, to be what is called an honorary diplomate. This is an honor not frequently bestowed and is awarded for continuing and significant contributions to the cause of justice and preserving the right to jury trial. It requires the unanimous vote of the executive committee and membership. Judge Perry took senior status in 1995 and never stopped working. Judge Perry died on July 29, 2011, at the age of 89. On that date, he went to work at the federal courthouse, attended a luncheon at the South Carolina Supreme Court, and returned to the Matthew Perry Federal Courthouse. He went home, sat in his favorite chair, and passed away. He spent all of his life to the last day on earth, his last day on earth, trying to make a difference for all South Carolinians. His funeral service was televised live on South Carolina Public Television. The New York Times and newspapers across the country published articles noting the death of a legal giant. And I have to say that Judge Perry chose me to be one of the speakers at his funeral, the greatest honor of my life. Most will agree that Matthew Perry was one of South Carolina's greatest citizens. He worked all of his life to make a difference for all citizens. We are all better because of Matthew J. Perry, Jr.
Thank you, Luther. I'd now like to introduce Kirby Shealy. Kirby is a lawyer here with a law firm called Adams and Reese, former president of ABOTA, is now a national representative to the National ABOTA Board. And Kirby is going to introduce Judge Lydon.
Thank you, Dick. So in law school, one of the things that they teach you is to be loud, be brief, and be seated. And today, by order of Judge Lydon, I'm going to be brief and be seated. Judge Lydon is a lawyer, as you've heard. She is the former United States Attorney for the District of South Carolina, and she currently serves as a United States District Judge for the District of South Carolina. So she is a judicial officer in a branch of the federal government that owes its existence to the Constitution that we are celebrating and talking about today. But Judge Lydon, wears many hats. She's also a wife and a mother, and she is passionate about the rule of law, as you're going to hear right now. Thank you.
Thank you, and good morning. As I speak to you from South Carolina's beautiful State House, where many laws have been debated and passed for 160-something odd years, I want to call your attention to the very first legislation, not of this State House, but of the very first Congress. The first bill proposed in the House of Representatives and the first act signed into law by President George Washington was an act that dealt with the oath of office. The act mandated that the oath be administered in this form: I solemnly swear to support the Constitution of the United States. Today it reads, I do solemnly swear to support and defend the Constitution against all enemies, foreign and domestic, and to bear true faith and allegiance to the same. In other words, I pledge allegiance to the rule of law. I've taken that oath a number of times, most recently when I was appointed U.S. Attorney for the District of South Carolina, and then again when I was appointed to the federal bench. You have not taken that oath yet in your young lives, but you are James Otis scholars, and I suggest that with that comes the responsibility that you pledge allegiance to the rule of law. What a privilege it is to speak to this generation about the importance of the Constitution, and what a responsibility I consider it. I'm very grateful to our forefathers, but also to the men and women after them for the Constitution. For many have gone on to defend the Constitution over the last 235 years. And you will have to do your part to make sure we have our Constitution for another 235 years. The Constitution is our preeminent rule of law. It is the law that provides the rule of law for the rest of the country. I'm here today to hopefully impress upon you a love for and passion for the rule of law. I hope you go home tonight and talk about it over dinner at the kitchen table. And I hope that you will continue to talk about the rule of law over many dinners in your future. If you understand the rule of law, you will understand the greatness of our Constitution and why it is due allegiance and faithful defense. But what is the rule of law? In America, the law is king as opposed to the king being law. And that is how you boil down the American Revolution. The colonists no longer wanted George III to rule. They fought to be free of him and his tyranny. Of course, it wasn't enough for them to win their freedom. They then had to go on and figure out how to govern themselves, since they were no longer going to be governed by a king, right? And brilliantly, they did just that. After winning their freedom, our forefathers went on to form a government of laws and not of men. Our government would be founded on the rule of law principle. And that principle goes back to Aristotle, and many would say the Magna Carta was the birth certificate of the rule of law, revealing to us this concept that the king shouldn't be above the law, but it was our forefathers who took that concept and through the Constitution formed an entire government based on the principle of the rule of law. An entire government built on the notion that no one, but most particularly our government, is above the law. Now, as I speak of the rule of law, I do not want you to think legislation. A government of laws and not of men is not the same thing as a government of legislation. Certainly, the term rule of law can encompass legislation, but I want you to think higher. I want you to think loftier. I want you to think fairness and equality. All are equal under the rule of law. The peasant and the king, the CEO and the janitor who cleans his office. It is a majestic sounding principle, but it is more than a noble saying, and I want you to be able to explain it to anyone after today. And I will tell you how I first really came to begin this appreciation of the concept of the rule of law. Back in 2007, I was teaching a course to the youth of our church on injustice. I wanted them to love justice because, as I explained it to them in terms of our faith, God hates injustice, and so they should hate injustice. And as I studied injustice and what it looked like in the world, I was appalled to discover the extent of injustice in other countries. I was shocked to learn, for example, that worldwide we have a terrible slavery problem. I learned of children as young as 4 who had to work to earn their freedom in India. Instead of kicking balls or coloring or playing, they rolled tiny cigarettes all day long or make bricks out of mud. I learned of very young girls in Asian countries who were forced into prostitution. I began to see how unjust things were in other parts of the world. Our world is filled with other countries that do not uphold the law. But as I did my research for this course with the youth, I kept bumping into this phrase, the rule of law. And then ultimately, I stumbled upon the World Justice Project. It was a project that had just been launched. This was 2007 when I was teaching the course, and the World Justice Project had been launched in 2006. And its goal was to promote respect for the rule of law. At that time, William Hubbard was a Columbia lawyer. He's now the dean of the law school. He was president-elect of the American Bar Association. And I knew William, so I emailed him and said, "What is the World Justice Project?" And so he explained it to me, and he said that their first goal was to begin holding conferences around the United States to promote respect for the rule of law. And the goal was to have all sorts of citizens at these conferences and not just lawyers. And so I volunteered to put on a rule of law conference here in South Carolina. And I began putting together a group of teachers, architects, lawyers, ministers, politicians, doctors, bankers, and I called them to ask if they would come to my rule of law conference. And to a man, every call was met with, the rule of what? What is this conference? No one understood what we were going to do, but somehow they came. And at this conference, speakers talked about injustices around the world. We discussed countries where there is no justice system at all. And we also discussed challenges at home to protecting the rule of law. We explained what the rule of law meant. And when I consider my most worthwhile work over the last 35 years of my legal career, this is at the top of the list. And I think what made it such a significant event was that there were so many people there that were not lawyers. They were not people who dealt with the law for a living, and yet they came to understand its importance to their lives. They came to understand that the law protected them and ensured their freedom and liberty. And at least for a day, they didn't take it for granted. And so today, I want you to understand it too. I hope that you will safeguard the law, safeguard our supreme law, the Constitution, and promote respect for it always. I always begin on a very basic level when I discuss the rule of law and explain what it means. The rule of law makes your world orderly and safe every day, and you don't even pay attention to it. I got here today safely because of the rule of law. People stopped at stop signs, and they obeyed the speed limit. They went on green, and they stopped on red. The rule of law let me get here in an orderly way. I didn't have to worry about whether cars knew to stop on red and go on green. I didn't have to worry about whether some people had to stop, but others didn't because they were more powerful or made more money. Later today, I may eat lunch at a restaurant, and I can enjoy my meal and not worry about whether it will make me sick. I can feel at ease because there's an A on the door. Those folks, before they could serve me, had to make a certain grade, and the restaurant will have to continue living up to inspections and making that grade to keep their doors open. I bet many of you know about countries where it's not safe to drink the water. Those countries don't have laws that protect the water like we do. Later today, I will enter more buildings, and I don't have to worry about whether the roof might collapse on me. Because buildings in the United States have to be inspected, and you have to get a certificate of occupancy before you can open the doors. It is not that way everywhere in the world. At that rule of law conference that I held, one speaker talked about how in some countries, it is who you pay that gets things done. There are not rules and regulations for everyone to follow. Instead, those who can afford to pay the inspector get the permit for their building. I had a client once who was trying to open a restaurant in another country, and he told me this was exactly what he had to do. Envelopes of white envelopes of cash, but not just one. He had to pay the first person who got him to the second person, who ultimately got him to the person that would give him the permit to open the building. And how are the people in that area going to feel about going into those buildings. For they know how it works. They know it's who you pay, and that doesn't give you a lot of confidence in the building. But let me keep going in my explanation of what the rule of law is. This past May, my husband and I traveled to Kosovo to teach at a school there. We were teaching them how to try a case, and we had a mock trial that they performed at the end of the week for their family and their friends and their classmates. But the first thing we did on that Monday morning when we started was to try to give them an explanation of the rule of law. We played a game to make the point. The game was called Guess My Rules. My husband was in charge, and he was the only one who knew the rules. We had two teams. The game looked a bit like soccer. We had goals set up on each side of the gym, and each team could score a goal by putting the ball through their scoring end. My husband, whom the students called teacher, would not explain the rules, and the students could not ask what the rules were. When a student broke a rule, my husband blew the whistle and told them to sit down. The aim, of course, was to score a goal without breaking the rules and getting put out of the game. So the students just had to sort of try to figure out what the rules were so that they didn't break them. So for the first few minutes, the rules were, number one, everybody could play. Number two, only the boys could kick the ball. So if a girl kicked the ball, my husband blew the whistle, and without telling her what she had done wrong, he told her to sit down. She was out of the game. A few minutes later, without telling the students, he added some more rules. For example, now no one was allowed to move with the ball. So now the children didn't realize it, but they couldn't run and kick the ball. They could kick the ball standing, and they could pass the ball in a standing position. Of course, they kept running and kicking the ball and running and passing the ball, so my husband was now blowing the whistle at them and telling them to sit down for this. And then there were more changes in the rules. The game was utter chaos. They didn't know the rules. My husband kept changing the rules, and the rules only applied to certain players at certain times. I cannot tell you how many times after my husband blew the whistle and told them they were out of the game that they threw up their hands and just yelled at us, "This isn't fair, this isn't fair." Which leads me to another part of the definition of the rule of law. I told you that the laws establish order, for example, to get me here safely today or to eat at a restaurant without worrying about being sick. Well, the laws must also be clear and fair, publicized and stable, meaning they don't change every 5 minutes, so that everyone knows the rules we are governed by. The students wanted to know the rules, of course, as we started the game, but we didn't tell them. We were trying to teach them this very important principle of the rule of law, and they got it a whole lot better by having to play the game and not know the rules. They were frustrated. They felt it wasn't fair. They didn't like that the rules changed every 5 minutes, or that some rules only applied to girls, or sometimes just boys, and that they couldn't even figure it out until there were enough whistle blows and they were pulled out of the game. Again, chaos reigned, and it wasn't fair. The colonists felt this frustration. How dare King George III make the rules? And how dare he keep changing them? And different rules for Americans than for the British. The king was in charge, and he and his ministers ruled over the colonists. So you can see what sorts of things the Kosovar students might have been frustrated with us. But we know exactly what our forefathers were frustrated with. If you look in the Declaration of Independence, our forefathers argue their case for what they are doing. It's not a long document. They're simply setting out a defense for what they are about to do in breaking away from British rule. You know the beginning, where our forefathers wrote, when in the course of human events it becomes necessary to separate, right? Well, they go on to explain why it's necessary to separate. They call the king a tyrant, and then they say, and now we're going to state our case for the whole world to hear. And they list 27 things that he has done to them. And what do you think most of them were about? The law. To sum it up, he was moving legislatures from where they normally met to places where they wouldn't have access to public documents that they needed. When the legislative body in Massachusetts wrote a petition saying the king had no right to tax the colonists without their consent, he decreed that the next time the assembly met, if they didn't reverse course, they would lose their right to self-govern. They wouldn't reverse their course, and they in fact lost their right to self-govern. Many other assemblies would ultimately be dissolved. The New York Assembly voted on a provision against housing British soldiers, and they were forbidden from creating any more laws or any more voting. The king removed judiciary powers in America. The people couldn't put judges in place, so the king started doing that. He began paying for the judges. He became their new bosses, and he denied the colonists a right to a jury trial, something all Englishmen enjoyed. Instead of a jury trial, the colonists would now be tried by a judge who's being paid by the king and whose tenure is up to the king. That's what our forefathers were upset about. Injustice was on their mind when they declared their independence. And of course, we know that America won its independence. They got their freedom. But then what? Can you imagine? The colonists won the right to be in charge, like the king had been in charge, like my husband was in charge. But what would it look like now? Can you imagine starting from scratch? It's one thing to come up with a game and some rules, but they had to come up with a way to govern an entire country. And what do we know would have mattered to them? Well, certainly the same things that mattered to the children in Kosovo who were playing our game. They wanted order, not chaos, and they wanted things to be fair. That's what our forefathers were upset about, and that is what was on their mind when they formed a more perfect union than the one they'd had through our beloved Constitution. So against that backdrop, our forefathers set up a government where people would choose their representatives. We didn't want a king, but we didn't want a mob either. So the people would govern themselves, but they would do it through representatives that the people controlled by putting them in or taking them out of office. Our forefathers also understood that a federal government was necessary. We were a collection of individual states, but we were at the same time a union or set of united states. So some centralized government was going to be necessary. But our forefathers took steps to make sure that government would not be too powerful. They wanted most of the power to remain with the states, who were closest to its own citizens who would put them in office, right? The people will control the government and never again the other way around. And they decided, as John Adams put it, and as you've heard today, we will be a government of laws and not of men. But what does that mean? Remember, it does not mean legislation. It means the rules wouldn't be arbitrary, like my husband's rules were, or King George's rules were. It meant, Luther, that they couldn't be made up on the spot like they were for Judge Perry after he graduated from law school, and now all of a sudden there was a test to take. It meant the rules had to be consistent and clear, not difficult to understand. Have you ever parked somewhere and someone inevitably in the car will say, well, there's not a sign saying you can't park here. You're trying to figure out whether you can park there. And someone will point out, well, there's not a sign, right? We know, we understand that these things have to be marked for us, right? Before you can hold us to it. The law has to be clear and publicized so that we all know what the rules are. What else does it mean? It meant, and this is critical, that everyone is held to the same standard, regardless of how wealthy or powerful they are. Under the rule of law, the law is applied equally, not just to girls, like our game in Kosovo, not just to the poor or the black or the Hispanic, not just to citizens, but to the government too. Under the rule of law, the rules are known and they are clear. They don't change on a whim, and they apply equally to all. That is what John Adams meant when he said we will be a government of laws and not men. And so they set out all of this in our Constitution without ever writing the phrase, the rule of law. Our forefathers built a government based on the principle of the rule of law. But our forefathers did not leave it as a lofty principle that we are to aspire to. They gave that principle real legs so that we really would be governed in a manner true to this ideal of fairness. Our forefathers put on paper, government and the governed are subject to the same laws, and all will be equally protected by the law. Here is what our government will be allowed to do. Here is the law that will control our government. They established the rule of law for our government. They involved men as necessary. They're setting up a president, setting up a Congress, setting up a judiciary, but they ensured we would never have a king again. And they knew, they understood there's something about the people that want a king. You can watch that today and watching all the news of Queen Elizabeth's death. People are drawn to a monarchy. But our forefathers made sure that there would be no one powerful man or powerful group that would hold all that power and not treat others equally. Our brilliant forefathers put safeguards in the Constitution to check that power. They divided the power up because that is what a principle like the rule of law requires. Our forefathers made sure no one man, no one branch would have too much power, because when that happens, you can end up with a situation like the Kosovar children had with my husband. He could make the rules, he could make them vague and random, they didn't make sense, he could change them, he could decide if you broke them, and then he could punish you by making you sit down. But if he only gets to make the rules, and someone else blows the whistle, and even yet another person decides whether you really broke the rule at all, well, then that's fair, and that's the rule of law, and that's the brilliance of our Constitution. Our forefathers, through the Constitution, said, stay in your lane, lawmakers. Stay in your lane, Mr. President, and stay in your lane, judges. If you occupy two lanes, you'll become too powerful. And of course, you know that I'm talking about the doctrine of separation of powers. That was the brilliance. They also made sure they kept the federal government in its lane because, again, they wanted the states to have the power because they believed the people could govern themselves, and the states are closest to the citizens who elect them. How brilliant they were. And I suspect that it had something to do with what they had lived, the tyranny. To hearken back to Kosovo for just a minute, on my first day there, I sat down in the cafeteria, and a girl came and sat down with me. She was a rising junior. In flawless English, she began telling me about her plans. Now, mind you, Kosovo is a very, very poor country. There are very limited opportunities for education, and there are hardly any job opportunities. But she told me about her plans to go to med school, but that the reason she was going to med school was just to use that position ultimately to run for office and help her country. She then began listing for me the issues her country faces. Her generation has inherited many issues following what was an horrific war that ended in 1999. They won their independence just over 20 years ago. Theirs is a very young constitution. They are just building the rule of law there, and it certainly isn't where America is. So much of the change she described to me that she wanted to see was going to involve passing laws. For example, she brought up pollution. They don't have laws like we have over there. Kosovo is about the size of Rhode Island, but it has been described as the 5th worst country in Europe for pollution, and it's causing terrible health problems in Kosovo. At some point when she paused, I commented that I was very impressed that she understood her government so well and the issues that her country faces. She paused for just a few seconds and then looked at me sort of matter-of-factly and said, "I guess it's because I'm so impacted by them." What incredible insight. Our forefathers lived the tyranny of a king. They lived the tyranny of arbitrary laws that changed constantly and weren't fair. They were impacted by too much power held in the hands of one, and thus they gave us the solution. Impacted by the injustice of a monarchy, they gave us a republic. Impacted by being told they couldn't govern themselves, they gave us a constitution that laid out exactly how to do just that. And impacted by the abuse of power, they placed all the power in a concept called the rule of law. And this is where you come in. Like the young lady in Kosovo, I want you to understand the impact of what you have inherited. You must educate yourself and you must educate others. First and foremost, with our history. You must understand what our forefathers did, what they lived, and what caused them to declare independence. The debates that went on and where they landed at the end of those debates as they formed our government. Ours is the oldest active constitution in the world, and our Constitution has gone on to influence every other constitution in the free world. And you must understand these things. You must understand our Constitution, and you must understand our government, a government of the people, by the people, for the people. And you need to understand this sacred principle, the rule of law, and pledge your allegiance to it. Please don't take for granted the privileges of your citizenship. America was founded on the rule of law and on its preeminent rule of law document, the Constitution. You know, we teach young people to give back and serve, and we've done a good job of getting the word out on that. I think you have to list your service on college applications these days. A lot of great service is going on by young people. But being a good citizen requires more than feeding and clothing the poor. Feeding and clothing the poor is very important, but it's not enough. Have we taught you how to defend your Constitution? I think that is what programs like today are about. You will have to figure out in what manner you are going to defend your Constitution. Maybe you will run for office. Maybe you'll become a judge. Maybe you will educate others. Maybe you'll host your own rule of law conference, and I hope you'll call me because I'll be happy to help. Maybe you will be parents who raise good citizens and teach America's history around the dinner table. Maybe you will elevate the conversation around you and with gentle words oppose criticism of the rule of law and our Constitution. Promote respect for our Constitution and our governmental institutions and the sacred rule of law. I try to promote the rule of law through my role now as a judge. I work hard to make sure that everyone in my courtroom believes they've been treated fairly. I want them to leave knowing they've been heard. I talk to potential jurors on jury selection day about why they shouldn't try to get out of serving on a jury. I tell them about the blood that was shed to get that right to a jury trial back. When I'm sentencing defendants, I talk to them about the expectations of the public that I uphold the law. It gives the public confidence in the judiciary. I want citizens leaving with a real respect for our judiciary and a real respect for the rule of law. And I travel to other parts of the world which are hungry for the rule of law we enjoy, and I work to help them achieve the principle and incorporate it into their country. There are many opportunities for you to engage as a grateful citizen and to defend and preserve what we enjoy here. I'm going to close by reading to you portions from a political speech Abraham Lincoln gave many years before he became president. Lincoln's speeches are amazing. I commend them to you to read. This one, he was 28. He would be 52 when he became president. The speech is called The Perpetuation of Our Political Institutions, an address to the Young Men's Lyceum of Springfield, Illinois. Lincoln understood his government. He understood and revered our Constitution. He begins by talking about all we inherited from our forefathers, including a great system of government. And here's what he said. We, when mounting the stage of existence, found ourselves the legal inheritors of these fundamental blessings. We toiled not in the acquirement or establishment of them. They are a legacy bequeathed us by a once hardy, brave, and patriotic, but now lamented and departed race of ancestors. He goes on and on talking about the gratitude we owe them. Again, a beautiful speech I hope you'll read. And then he begins to warn us of what can undermine all that they left us. He says the attack won't come from Europe, Asia, or Africa. He says it won't be Bonaparte. He says we will be the problem. We will be the author of our own demise. What does he mean? He tells us, I mean the increasing disregard for law which pervades the country. He warns that an attack on the rule of law would be our downfall. At that time, Lincoln was very concerned about mob rule. There was a lot of mob justice going on. Remember, our forefathers gave us a republic form of government to avoid a king, but also to avoid rule by a mob. Lincoln goes on to warn that a disrespect for the rule of law will ultimately lead to disrespect for all of our governmental institutions. Lincoln understood government. He understood history, and he understood the importance of the rule of law. And so he pleads with these words, the most famous part of the speech: let every American, every lover of liberty, every well-wisher to his posterity swear by the blood of the Revolution never to violate in the least particular the laws of the country, and never to tolerate their violation by others. As the patriots of '76 did to the support of the Declaration of Independence, so to the support of the Constitution and laws, let every American pledge his life, his property, and his sacred honor. Let every man remember that to violate the law is to trample on the blood of his father and to tear the charter of his own and his children's liberty. Let reverence for the laws be breathed by every American mother to the lisping babe that prattles on her lap. Let it be taught in schools, in seminaries, and in colleges. Let it be written in primers, spelling books, and in almanacs. Let it be preached from the pulpit, proclaimed in legislative halls, and enforced in courts of justice. And in short, let it become the political religion of the nation. In other words, let every American pledge its allegiance to the rule of law. Thank you.
Thank you, Your Honor. I'd now like to introduce Teely McVeigh to you guys. Teely is a partner in the law firm of Castle and McVeigh. She's a trial lawyer, which means she goes into court and represents clients in front of juries. She was the recipient of the ABOTA Trial Lawyer of the Year Award a couple of years ago. She's currently our president of our chapter. She's a wife and a mom, and I can tell you she's one of the best, most passionate, most effective lawyers that I've ever seen stand up and talk in a courtroom. And so she's going to introduce Judge Hill.
Thank you, Dick. Good morning. I'm so excited to be celebrating Constitution Day with you all and to be able to hear from such amazing speakers. And we have one more incredible jurist who's going to speak with us today. Judge Gary Hill is here. He is from Greenville. For 13 years, he served in the circuit court up in Greenville. That means he tried cases in front of juries. And I was lucky to try a few. Some I won, some I lost. Try a few in front of him. He served as a circuit court judge for about 13 years, and then 2017, he was elected to the South Carolina Court of Appeals, where he has served since then. That means he hears appeals from all the circuit courts. He's going to talk to you today about George Washington's chair. Judge Hill.
Well, thank you, Ms. McVeigh, and thank you, ABOTA, for the opportunity to be here today and the invitation to speak to y'all. It's very exciting for me to have this opportunity, and it's a wonderful event to hear about our history and our constitutional history. We know the saying well that those who don't learn from history are condemned to learn it from Hollywood. So this is a wonderful program y'all put on. So this morning on Constitution Day Eve, I want to invite y'all, you've been sitting there for some time now, to come with me on a field trip. We're going to travel both in time and space. We're going back 235 years to May of 1787, and we're going to journey from this spot in Columbia to a spot 620 miles north, Philadelphia, Pennsylvania, to Independence Hall. When we get there, we will see 55 people inside the hall. They are the delegates from 12 of the 13 former colonies. Rhode Island didn't bother to show up, but it is in the same hall that you might remember the Declaration was signed 11 years before. The Revolutionary War has been won. It had ended in 1783. And George Washington, the man whose statue is out there on the steps of this Capitol, the general who had won the war for independence by defeating the armies of King George III, had been picked by the delegates to preside over the convention. When George III heard that after the Revolutionary War was over, Washington was preparing to give up his command to the Continental Congress, he thought about it and said, if he does that, he will be the greatest man in the world. He did do that. He laid down his sword to the Congress, showing by example that whatever this new nation was going to be, it was not going to be a military dictatorship. And as he prepared to take his seat in the presiding chair, the delegates could see his chair had an unusual decoration at the top. It had a carving depicting the top half of the sun, painted in gold leaf with rays shooting out from the sides. George Washington was by then perhaps the most famous man in the world, certainly the most famous man in America. The second most famous man was also there in that room, and that was Benjamin Franklin. In fact, he had arranged to nominate Washington to preside, and this was Philadelphia's favorite son, Dr. Benjamin Franklin. Can you see him? He was now 81 years old. We might call him a founding grandfather, for he was far older than the average delegate age of 44, but still far wiser than most anyone walking the earth. And here he comes, but not walking because of bad health. He was carried to the hall in a sedan chair. And here he is, balding, portly, suffering from gout and other pains, wearing bifocal glasses that he had invented. In short, a strikingly handsome man. He was one of the 6 delegates who had been in the hall 11 years before to sign the Declaration. Dr. Franklin's fame came from his work as a scientist, a community leader, and a diplomat. In addition to inventing bifocals that many of us carry around today, he also conducted that famous experiment with the kite and the key during the electrical storm that proved the single fluid theory of electricity, that a feat that would have won the Nobel Prize hands down if that prize had been around. If you have a smartphone, you're carrying around with you 2 modern versions of things Dr. Franklin also invented, the battery and electrical capacitator. He started as a very young man in Philadelphia, the first fire department, and a little public school that is now known as the Ivy League institution of the University of Pennsylvania. If you have ever checked out a book at your local library, you have participated in another of Franklin's community experiments. Free access to education for the people, a way for man to pursue the American dream. And what a dream it was. Franklin embodied it. He came from nothing. He was part of an indentured servitude to his brother, but he ran away from that, and he became fabulously wealthy as a self-made man in Philadelphia as a printer and writer. And he found fame and success by applying himself in the service of science and the people in the community he lived in. His doctorate was not a medical degree, but an honorary one bestowed by St. Andrews University in Scotland. He also had degrees from Harvard and Yale that were also honorary. After the Declaration, the Continental Congress sent him to France, where using his diplomatic skills and his worldwide fame, he finessed the French to enter the war on our side, assuring us victory, a feat that many rank up with Washington's leadership of our army in securing us the Revolutionary War victory. He invented things by experiment, and now as a delegate, he was embarking on the greatest experiment of all, how to find a way to create a government for a free nation. The stakes were enormously high. The previous attempt, the Articles of Confederation, had failed spectacularly. The eyes of the world were on the delegates. Nothing less than the fate of democratic self-government was in their hands. For 4.5 months, they debated, they argued, and they compromised. In the end, they came up with a document they could agree upon. It was short, only 4,400 words, about 10 single-space pages long, and has 7 sections or articles. Now, we may ask, what is a constitution for? Well, they tell us in the preamble, we, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common welfare, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Now, the real genius of the Constitution lies in 2 things that are never mentioned in it. And Judge Lydon alluded to them, but they are the separation of government powers and the checks and balances on those powers. Separation of powers was the design the delegates used in their experiment. The theory that if government was designed so that power was divided, there was less chance of abuse. You well know this because Ben Parker said it to his nephew Peter Parker, with great power comes great responsibility. Some attribute that phrase to Voltaire, but Spider-Man's uncle is good enough for me. Now, fresh from their war against British tyranny, the framers well understood the dangers of consolidated power. James Madison, in a famous phrase, wrote that ambition must be made to counteract ambition. If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. So the Constitution divides power into 3 branches. Legislative power is in Article 1 because it's the most important. Article 2 is executive or presidential power, and in Article 3, judicial power. And each of these powers was limited and enumerated. But it was not enough that they be divided and diluted in theory and structure. The delegates were not naive about human nature. They knew well the ability of power, proven by the bloody pages of history, to corrupt those with it and the ease with which they increased and abused it. They know that putting power in one place, whether in a tyrannical king, an out-of-control parliament, or an oppressive majority, was the biggest danger to liberty. So to give their experiment more muscle, they had to have controls other than just separation. They had to have a way that each branch could check the power of the other. And so throughout the Constitution, they put in ways to apply the brakes. Let me just talk about a few of them with you. The first is the oaths of office. And you heard Judge Lydon talk about that and Speaker Smith talk about it. And that is an important check on the conscience of government officials. The second way they did it is that the legislative power, again, the most important, would be split in 2. No legislation can be passed without both chambers agreeing to it. Even then, the president could veto it. But, and this is a check on a check, the legislature could override that veto by a 2/3 vote. The president could be impeached by the Congress, but it required action by both chambers and, again, a supermajority. The president was given the power to nominate the judges and conduct foreign policy, but the Senate was given the power to advise and consent to the nominations and the power to ratify foreign treaties. The Constitution was made the supreme law of the land, and the people, through the Constitution, they would ratify, and the judges who had sworn to uphold it could strike down unconstitutional legislation or executive action. The legislature could impeach the judges. The people provide the ultimate check. They can vote the president or the legislators out, but, and this is where the balance may be the most brilliant, the people can't vote everyone out at the same time. The terms are staggered, and the elections are at fixed times to promote stability, even during intense political upheavals. The founders also placed a check on themselves. Article 5 sets out how the Constitution could be amended. So if their experiment didn't work in some way in the real world, it could be tweaked and fixed. And finally, there was, as Judge Lyden just eloquently spoke about, the check of the rule of law. So now the Constitution has been drafted, and it's time for the delegates to vote to approve it. Not everyone is 100% happy about it, but politics is often the art of compromise. Speaking in favor of approval, Benjamin Franklin gives a speech. He says, "I'm not crazy about some of the stuff in this thing, but I've lived long enough to know that often things I thought I was certain about turned out to be wrong. And besides, this is probably the best we can do." Ultimately, the states unanimously voted to approve it. On the day they sign it, September 17th, 1787, Franklin rose to speak again, and he looked at George Washington's chair. According to Madison's journal, Franklin said, "I have often looked at that picture on the back of the president's chair during this convention, and amidst the vicissitudes of my hopes and fears about the issues we have faced, I could not tell if the sun painted in his chair was rising or setting. But now at length I have the happiness to know that it is a rising and not a setting sun." As for Washington, he wrote his friend Lafayette that the birth of the Constitution was nothing short of a miracle. Miraculous it may have been, but it was not perfect. As you heard Mr. Willis say, there were things left out and people left out of the Constitution. The sun may have been rising, but it was not all blue sky. There were clouds on the horizon, the dark clouds of issues the founders had not fully dealt with, chiefly slavery and the emancipation of women and other issues. In fact, if you go to the National Archives today, and maybe you've been there, you will see the original Constitution and the Declaration. And you will see displayed above them a huge famous mural of the founders. And it depicts a dark cloud hovering right above Thomas Jefferson's head that is meant and was meant by the painter who painted it in the 1930s to symbolize the issue of slavery. And if you look at that cloud sideways, you can see how the artist drew it in the shape of Abraham Lincoln's head. So the Constitution was not perfect, but it was a miracle. It's now the oldest written Constitution in the world. It's also the shortest. By comparison, the Constitution of the European Union is over 200 pages long and has some 80 amendments. There's a destructive tendency we all have to romanticize the past, to think things were always better before than they are today. There is a belief that today America's sun is setting, that our golden age is behind us, and even that we may be seeing the twilight of democracy. Many say that for the first time in our history, current generations don't think they will do as well as their parents did. The keepers of the doomsday clock tell us we're as close to nuclear annihilation than we have been at any time since 1947. And when we talk about these founders and how great they were, we may think that, boy, the men and women in Washington today just don't match the marble. It would be easy to think all these things and join the setting sun crowd, but it would not be American. For America is the only country ever built on an idea. We have no shared race, ethnicity, or common religion. Instead, we have a shared dream that a free people can govern themselves. And that dream, that ideal, that aspiration is written in the preamble to create a more perfect union to secure the blessings of liberty. Now, those are not the words of cynics or naysayers. Let's go back a minute to our friend Dr. Franklin. When he was minister to France, he saw the first flight of a hot air balloon in history. It was a grand affair. He was amazed by the wonder of it all. He heard, though, a grizzled Frenchman in the crowd say, "Yes, but what is it good for?" And Franklin turned to the Frenchman and asked, "What good is a newborn baby?" Not only would it be un-American to say our sun is setting, it would not be true. And knowing true facts is essential for any country to protect its legitimate institutions. Those who think the age of the founders was our golden age may not recall that while the Constitution was being miraculously produced, doctors were still using leeches. George Washington died, perhaps, because of this very treatment. The average life expectancy was 38 years old for a man. One of every 3 children born died in the first year of life. You may have seen that the great historian David McCullough recently died about a month ago. He won the Pulitzer Prize for his biography of Harry Truman and another for his biography of John Adams. He had a very optimistic view of our country, and he had that even in spite of his vast knowledge of our history. 10 years or so ago, he said something in a speech that stuck with me. He said, "People who think things were always better in the past are just flat wrong." And he used the example of the Spanish flu epidemic in 1918. It had killed 1.5 million people in this country alone. Can you imagine living through that? He said. It led the news every day in every paper, this awful disease that we don't know where it came from or how to get rid of it. Well, of course, we can imagine it now because we have lived and are still living through the COVID-19 pandemic. But look at what happened. Before COVID-19, there had been many other coronaviruses. Despite all the efforts, there had never, ever been a vaccine developed for any of them. When COVID-19 hit, dedicated scientists, researchers, and doctors worked day and night, and a vaccine was developed in less than a year. So when we're tempted to think our sun is setting, we should remember to never underestimate the power of human ingenuity and of human will. We should remember the many watersheds of human progress that have happened only fairly recently. The eradication of smallpox from the face of the earth in 1980. This was a disease that had been around over 3,000 years and killed more people than all the wars of human history combined. The near eradication of polio has been achieved. Prenatal care and childhood vaccines have been developed at unprecedented rates, and there's been effective treatment of many other diseases. We should think about the fact that extreme poverty has decreased faster in the last 20 years than any other time in world history. The fact that cancer survival rates have increased significantly. The fact that the people's access to clean water across the world has gone up 30% in the last 40 years. The fact that basic literacy, that 10% of the people in 1800, only 10%, could read and write. Today, that number is 86%. The fact that in 1990 there were 14.5 million crimes reported in the United States. By 2015, that number had dropped to 9.5 million. And think about this. Willie Nelson, Dolly Parton, Bob Dylan, and Stevie Wonder are all still alive and still making music. Now, I'm not saying everything in the world is fine. It's not. I suggest, though, that the facts around us, when examined closely and honestly, and not through the lens of the sky is falling headlines favored by the media, of course, that sells a lot better than the sky is fine today, again, because good news is not news. But all of this should help us say, hey, there are bad things and evil in the world, but the sun is not setting. It is rising, and it is rising on you. You are the next generation of scientists, diplomats, servants, and community leaders. It is you who inherit both the rising sun and the storm clouds. And today I urge you to please keep the American experiment alive. Continue to secure the blessings of liberty and create a more perfect union. We have to take up the challenge of the founders with all their commitment and learning, with all their curiosity and drive to seek a newer and better world. The liberty they bequeath to us is not the freedom to do as we please, to sit on our couches and surf our screens for the latest TikTok dance or be-real video. It's not the freedom to think someone else will do the hard things and take care of it all for us. It is instead the freedom to pursue learning and the liberty to better ourselves, to live our lives along the lines of excellence, to work for the betterment of our fellow man. So as our sun shines, remember what these founders did and seek what they sought. Strive to create a more perfect union, establish justice, secure the blessings of liberty, promote the general welfare. Trust that a free people can govern themselves, and pass on this legacy to your children too. Thank you.
Thank you, Your Honor. So you guys have been patient, right? And I warned you when we started this thing this morning, seems like a couple hours ago, that you guys had a chance to ask some questions. And so now this is your chance to talk. So I think what I'm going to do, I'm going to walk down. We got about 10 minutes, and I'm going to ask maybe Teely to preside, so we'll get some questions and try to direct them to the people who I think are the smartest people up here, and that's Judge Hill and Judge Leiden. And we'll go from there.
No pressure on you guys down there. You got a hand right here.
Tell us your name.
Is that on? Tell me what to do. Can you turn it on?
There we go.
All right.
Is that better? Yeah. Okay.
We've got
I'm Tate
Speaker
Sweat.
Smith here too.
What was that?
We've got Speaker Smith too. I'm sure
Okay.
he'll answer questions. No.
And I had a question for Judge Leiden. So you were talking about the rule of law and how it means that nobody, including like the powerful people, are above the law. So I was wondering, how would you go about fixing people in power being treated better, like in the judicial system?
Judge Leiden, you might have to come up here.
Treating the people with the power better?
Yes, ma'am. Like, how would you go about fixing that? Because I know that it's pretty common these days for people in like powerful positions to be like given lighter sentences or treated better than people without.
Oh, no, that shouldn't happen. And I mentioned that I work hard in my courtroom, and I believe my fellow judges do as well, to make sure that doesn't happen. And even as a prosecutor, let me back up a little bit. A prosecutor has a lot of power. The prosecutor's deciding who to charge, and that's the power to ruin somebody's life. And when I was a prosecutor, one of my heroes and somebody I looked up to in that role was Robert Jackson. Robert Jackson was an attorney general for the United States. He would go on to be on the Supreme Court, and he also led the Nuremberg prosecutions. And he has this incredible speech where he's swearing in a bunch of U.S. attorneys, and he ends the speech by telling them what a good U.S. attorney looks like. And he talks about the role of humility and handling that power with great care. And so even, as a young prosecutor, that had a huge impression on me. But I went on to prosecute some very powerful people in my career. Twice I did that. I mean no disrespect, Speaker, but many of them were in here. They were legislators, and we prosecuted them for corruption that was going on. And then later in my career, I also prosecuted a lieutenant governor for the state who had, he was then in the private sector and had not been honest with investors in the company that he was an officer in, and so prosecuted him. When I would talk to a jury in those prosecutions, I said to them, no man is above the law and no man is below the law, and we make no apology when we ask Representative so-and-so or Lieutenant Governor so-and-so to follow that law. So I have to tell you that my experience has been always holding the powerful to the law. And in the courtroom, I certainly do that. In fact, I have to guard against the tendency not to be harder on those that are more powerful and that are wealthier and that have had better opportunities. All I can tell you is that's how I try to conduct myself, but I also see my colleagues doing the same thing. And I guess I will promote that for others by continuing to do talks like this and setting an example for it. But there may be somebody else that has a better answer to that, so have at it. Okay?
Yes, ma'am. Thank you.
All right.
Anybody else?
My name is Bryden Tyne, and I have a question for Judge, was it Leiden? Leiden.
We're not going to let you sit down.
Okay, so my question is, what do you have to do to be able to work in a place like the State House?
Oh, in the State House? Well, I
Yeah.
never worked here,
Oh, okay.
so I never ran for office. In fact, the idea of running for office terrifies me greatly, so I may kick this one
Okay.
to the speaker.
And the question was, again,
What do you have to do to be able to work in a place like the State House?
you have to run for office and you have to file for office, and then you have to campaign. And nowadays, I was fortunate I didn't have a primary, but we have a primary election in June of every year, or every 2 years in the House, and then you have a general election in November that coincides with the federal election. So again, it's an interesting concept. You got to go out like you have to do anything. If you like a lawyer, you got to go try to sell your case to a jury. Had to go sell yourself to your constituents. And so in the House this year, after reapportionment, we have 41,000 constituents, and I'm up for election not only with the body as to be speaker over here, but I got to first get elected by the citizens of Sumter County. So you campaign, and you're always campaigning when you're up for re-election every 2 years, and that's why we call this the People's House, because we take the position that we are the closest to the people, because we have to face them every 2 years, where the Senate has to face them every 4 years, and Congress is every 2 years for congressmen and representatives up there, and 6 years for senators. So you're always campaigning, you're always trying to raise funds. Unfortunately, that's the art of that's mother's milk of politics, is money to be able to get your message out. But then also, what thing I've learned with most in my career, I've served, this is my 22nd year I'm completing up here, and I think it's very, very important that you always return your constituents' calls. They're your bosses, and they're the ones that need you, and so you don't ever ignore the people who elect you to serve up here.
How can students work in the State House?
How many students work in the state?
How can students?
Oh, how can students work in the State House? Oh, I thought you.
I know, I think he was. I'm just asking.
Yeah.
Oh, I hope I didn't miss the question. If you are a college student, then you can come up here, and we have pages that we call. Every member gets to appoint a page, and then every committee has a couple of pages, and then there's some room. They get mad at me when I say this, but there's some room for extra pages if people would so desire. But I think it's a wonderful job. I wish I would have had the opportunity to do that and go to school at the University of South Carolina. I think you basically need to be in Columbia in order to do that job. But we have pages that sit on the floor in all those chairs and benches over there is where they sit, and they do things as to, help make sure the bills get delivered over to the Senate, and even the more mundane of getting members coffee every once in a while.
Yep.
All right.
That's it.
Thank
Thank
you
you.
for the question. Are there any further questions?
Hi, I'm Natalie Tappy. I wanted to ask Mr. Smith, what is the keys to being seen, heard, understood, and respected, particularly in government?
Well, I think it's the same as characteristics that you should embody as in life as you do up here. You got to be genuine. You got to be trustworthy. And people got to be able to expect when you say something, you're going to keep your word. You watch through this process, and like I've said, I've served for a long time up here, and the ones who generally develop into the leadership are the ones that sit at that well, and the body trust what they're telling them. And, I think that's the most important aspect in life as a lawyer. I mean, I'll never forget one of the lessons. That's why I think lawyers make great legislators. But one of the lessons I was told by the first lawyer who hired me is you never be dishonest with your opponent. You never lie to the court. That's obviously a rule against. There's rules against that, but you don't misrepresent anything to the court or to other lawyers. And people got to trust when you say you're going to do something, you're going to do it. And I think that translates over here as trust, as respect, and as being an honorable person and man or woman of your word.
Thank you.
Thank you. Any other questions?
Name's Alex Gillespie. I had a question for Judge Leiden. So you had mentioned that laws must be clear, outlined, and stable in your explanation of rule of law. So how do you make that fit with something like the necessary and proper clause in the Constitution, which is kind of like open to interpretation about what's actually necessary and proper?
Wow. Well, I know. Somebody help me out too if they can. But, people bring cases perhaps that would touch on that. And there would be lots of arguments and briefs where each side would explain what they thought that meant. The court, or the particular application to the case, the court spends a lot of time, I guess, laboring over the language and doing the research and deciding. We do interpret the law. I will admit to you that some things are a little trickier to navigate, but fortunately, we have a lot of case law that we can turn to and better define or clarify what something can mean. Somebody please help me with that. Judge Hill, you got anything else?
Well, I think a good example.
You got to kind of consider streaming.
A good example of what Judge Leiden is identifying is laws that we get, whether in the Constitution. Some of them are easy, like the president has to be 35 years old. Well, there's not much ambiguity there. But sometimes legislation we get that is involved in a case, it may be ambiguous. For instance, we had a case a year or so ago that's a South Carolina statute that talked about a very young witness. And the question was a 12-year-old a very young witness? And so we had to struggle with that. So that, if that helps you any, that's kind of sometimes the legislative acts, statutes, they are ambiguous purposely because it's the result of compromise. They couldn't agree on, say, 12 years old being very young, or somebody may have thought 15 was a better age, but they both agreed very young was what it should be, and they left it up to the courts to interpret that.
And I would say, at the level of judge I am, I'm a trial judge, so I don't make law at all, but you can have challenges to laws because of the very reason you're pointing out, that they are vague and unclear. And sometimes the Supreme Court will agree, particularly in the area of criminal law. We've got some statutes, as Mr. Batiste, I know, will know that, certain extra punishments for violent offenders. Well, those cases make it up and go, well, what does violent offender mean? Isn't that a vague, unconstitutional, unclear regulation? And sometimes they'll say, yeah, that's not clear, that's vague, and that's unconstitutional. We're not going to apply it. So we guard against that. That's about the best I can do with that very good question.
Thank you.
We've got a couple more minutes. Anybody else?
Come on up.
Hi, I'm Vidya. I have a question for Judge Leiden. Sorry.
What you asking? Well, yes.
Okay, so I was just wondering, she talked a lot about, challenges other countries face and, implementing the rule of law. And, according to you, what's the biggest challenge, our criminal justice system faces today? And, how would you propose that we tackle that?
Still pondering that last question. I'm worried that we totally missed your point, and if we did, you could call it. We did? Okay. So you want to know the most significant challenge to our criminal justice system today. Wow. Okay, sure. And Mr. Batiste, if you have anything from your experience, there are a couple of issues out there, I guess. There's a school of thought that we put too many in prison and for too long. So I would say that's a significant challenge. And now from the position of judge, I can appreciate that because it's hard to sentence people to prison. And yet I have this obligation to protect the public. So that certainly is an issue. Always, I think, the people are going to be questioning, as they should, it holds us accountable, the equality of justice. What we've talked about today, are we treating everybody fairly? Are we feeding everyone from the same spoon? You certainly have seen challenges to the way policing goes on, for example. And, those kinds of challenges are great. They keep us honest. And so we don't shy away from those. That's a good thing. Anybody else think of another particular challenge to the justice system? I was telling Mr. Willis that in November, I have a group of judges coming from Bosnia to observe our court system. They have a very young judicial system. It's about 25 years old. They don't have a jury system. They don't want a jury system. I hope someday they'll feel differently about that because we really believe in the jury system. But they're coming over to watch, and one of the reasons that this group was formed to assist them is there's not public confidence in the judiciary over there. They think there's a lot of corruption, that the powerful aren't prosecuted, that the same justice isn't being meted out. I like to think that is not true here, but I also don't want to be Pollyannish about it, as Judge Hill warned me against, and even Mr. Willis and Mr. Batiste remind me that we have our own challenges here, and we must continue to promote that respect for the rule of law and that equality. So hopefully that answered your question.
Thank you.
Yeah.
I love all the furious note-taking that's going on when you're answering these questions, too. We've probably got time for one more. Anybody?
Come on. Yeah.
My name is Caleb, and I just had a simple question for Ms. Leiden. What was the name of that speech from Abraham Lincoln?
Almost know it by heart. It's about the perpetuation of our governmental institutions, and it's directed to the Men's Lyceum of Springfield, Illinois. But let me get the very exact name just in case. Yes. The speech is called The Perpetuation of Our Political Institutions, an address to the Young Men's Lyceum of Springfield, Illinois. The Young Men's Lyceum was a group formed for speeches, and that's why they gathered. And he addressed them. And please go back and read it. It is scary how relevant it is to today's times.
Thank you.
Yeah, so thanks, everybody. I think I'm going to take a point of privilege and ask one more question to Judge Hill and Judge Leiden, and it's designed to recognize something we all have in common here, which is we wouldn't be here if it weren't for great teachers. Great teachers who teach government and teach Constitution. I think everybody on the dais can remember the person that inspired them, the teacher that inspired them to become a lawyer or to become a judge or to pursue a career in justice. And so I would ask Judge Hill and Judge Leiden to maybe mention one person that they believe had influence on them, a teacher that got them where they are today. Judge?
All right. I'm going to have a point of personal privilege. I'm going to name two people, if that's okay. And one is a teacher at Wofford. I don't know if Merle, Speaker Smith had him as well, but his name was Vince Miller. And he was a terrifying teacher. And he was a fierce grader, and not many people wanted to take him. In fact, I stayed away from him until I became a senior. And then I finally kept hearing all these things about that. He really was a brilliant man and a brilliant teacher. But he taught English, but he knew a vast amount of things about our constitutional history. And I remember it was he who pointed out that I'd first heard this, but that the U.S. Constitution is the oldest Constitution, as Judge Leiden said, in existence in the world for a nation. But it's not the oldest continuously existing Constitution for all purposes, because the Constitution of Massachusetts is older. It was written by John Adams, mostly. And there's an interesting thing about the Massachusetts Constitution that, as our Declaration of Independence says that all men are created free and equal, in the Massachusetts Constitution that John Adams drafted, in its initial draft, it didn't say that. It said all men are created free and independent. And the reason that Dr. Miller was pointing that was because those words, those theories about independence and equality have really, that's made up a lot of our history over time, and it's still debated today. And the second person I would mention as a teacher would be my father, because he loved the Constitution, and he had a really extensive library about the founders, and he helped me understand the Constitution and helped me revere it like he did.
Well, I certainly had great teachers growing up, and I've often said that a good trial lawyer is really just a teacher. The highest of professions for sure. I would say my aunt, who was an English teacher, probably most influenced me. But really, I don't know why, and I really don't know why I started saying I was going to become a lawyer, but I started saying it in 7th grade, and if you say it long enough, you just have to go do it, and that is what happened to me. I just said it on and on. classmates always knew that was what I was going to do, and I just did it, and thankfully it worked out. It's been a great career that I've loved, but I wish you all well. I was thinking about your question to the speaker about how do you get here, and it seems to me that you all have sort of figured this out already, that to borrow a phrase that's become pretty well known, begin with the end in mind. You seem to be looking ahead already, and we would guard you against Facebook and other forms of social media. If you're going to run for office one day, maybe begin with the end in mind and think about that. And of course, if you're going to begin, or if you're going to hopefully end with a career in law, you're certainly in the right place, and exposing yourself to great speakers on the subject. And anyway, just wish you well. It's been a real privilege to be with you today. Thank you.
Thank you, Your Honor. So I hope we've accomplished what we set out to do when we came here today. Talk a little bit about the Constitution and the rule of law, and understand how it applies to each other and what we can do to preserve and protect it. Maybe we've inspired some of you guys to think about a career in law or pursuit of justice or in the legislature. If we've done that, then we've achieved our purpose. So I'd like to thank Judge Leiden, Judge Hill. I don't know if you'd known you were going to be on the spot with these tough questions, you would have agreed to come do this. So we really appreciate your time today. Representative Smith, for having us here and hosting us, and for your comments as well. This has been very special, and we want to thank all of you guys for coming, and everybody who's watching by streaming online. And also we want to thank your teachers, because I think we owe a tremendous amount of appreciation to them for putting you guys in the position that you're in. So with that, may I have a motion to adjourn? Move to adjourn. All right, second? I hear a second? Very good. All right. All in favor, raise your hand. All right. Well, there's your first legislative act. Congratulations. Thank you so much. We're done.